Hello and welcome to the Facts Matter podcast. I'm Guy Gordon with Eric Lupher, president of the Citizens Research Council, very firmly believing that facts should drive policy, not politics. Eric, chapter 6 of the Conversation.
We're working our way through it. A few more to go.
And for those of you that aren't sure what we're talking about, if this is your first stop by, Michigan voters will be asked in November whether or not this is a question that comes up every dozen years.
16 years.
Yep. Every 16 years, Michigan voters are asked whether or not they want to have a constitutional convention to basically reopen Michigan's constitution, which has been around since 1963. And we have looked at every article of the Constitution, 1 through 5. This is number 6, and today we're looking at the Judiciary. Not one of those areas where there has been a lot of successful attempts at amending the Constitution, Eric.
No, this was one article of the Constitution that you would argue that the 63 convention got right in many ways. There's some issues we'll talk about as things have evolved. It's been affected by other provisions in the Constitution and sort of the devil's in the details we've learned over time. But on the whole, you would give the 63 constitutional framers high marks for what they did with the Judicial Branch.
And they made a significant change during their conversations in 1961, leading up to the 63 Constitution, basically saying that Michigan will have one court of justice and that it all trickles down from there.
Yes, that was a very significant change and a change for the better we can see over time. Prior to the 63 Constitution and the laws that implemented it, we had a Supreme Court, we had appeals courts, we had different levels of courts, but the sort of hierarchy was missing, and the idea of if you were dissatisfied with a ruling in one court, what was your next step in the process? That was missing from everything. And so the biggest thing and the best contribution that they made was creating one court of justice and sort of a hierarchy going from the district courts, the circuit courts and probate courts, the Court of Appeals, and ultimately the state Supreme Court at the top, in giving those Supreme Court justices some administrative, some ethical standing, some teeth to enforce rules, set court rules, do things that affect the lower courts, and much as you would have in an executive branch or other places, the things flow from the top down now, and it makes a lot of sense when you get in and start looking at all that stuff.
Well, and an interesting historical wrinkle was that we didn't have a Court of Appeals until the 63 Constitution. If you wanted to appeal something, it went right to the Supremes. Now at least there's an intermediate step which clears a lot of dockets and helps to streamline things.
Right, and it's not a fact-finding court, although it's been cast. That's a whole different issue we don't need to get into. But it is sort of let's test what happened at the lower courts and make some light of that, so the Supreme Court then, as you say, has a lighter docket and can really assess things at a more global level. It's not caught up in the minutia and working through things. I say that, and then in my mind think about cases that have stretched on for decades. So Supreme Court cases that have stretched on for decades. So a lot of things, work in different ways, but yeah, creating that hierarchy really helped in a lot of ways.
So as we look at this, as you say, the framers did a pretty good job in terms of court organization, but is that an area where there might be opportunities for streamlining and greater efficiencies were we to have a constitutional convention, were it to be approved by voters?
I think this is something that certainly the delegates will look at. Could this be fine-tuned? I don't think in any way there'll be interest in blowing it up and doing it differently, but can it be fine-tuned? And what has happened, I think the law currently is broad enough that the courts have been able to tinker on the edges to deal with family law, to deal with drug courts, to create specialty courts. There's enough room within the law
Right.
as it currently stands. It's not so restrictive or not so prescriptive that there's the inability to deal with things gets in the way. But certainly the delegates, if there is a convention, will want to look at that and say, should they dictate change in some way, and how do you do that while still being still leaving enough room to make further changes if needed going forward?
Is there room for maybe some streamlining in terms of the relationships between district courts and circuit courts? I was always struck by what looks like an apparent redundancy in the system, that if a criminal case starts out first in the district court, then there is some processes there, and then you get bound over to the circuit court where the person is arraigned again and the defendant kind of goes through the same system. It seems a bit redundant, and that there could be some unification there, or maybe a greater division of responsibilities.
Right. That's sort of the details there, right? The things that you don't read about in the papers all the time, and you hear about somebody being bound over, and the sort of detail gets lost in all that. But certainly there's room for improvement and things like that. As we'll talk about some of the funding issues of the different courts, and that plays into that as well, right? Who's responsible? Like, how do you manage the dockets of the different courts?
Hmm.
So having a clear lines of responsibility, separating the district courts from the circuit courts and probate courts, will all be helpful. Could be done, I think, with some administrative rule changes now and some fixes. Um, we have a state court administrator's office that's pretty good at looking at those types of things and advocating for change when change is appropriate. So, yeah, do we need a convention for that? That's sort of an eye of the beholder type of thing.
We have seen with the other 5 articles that we reviewed, there are opportunities for basically constitutional cleanup, where a lot of things have been undertaken statutorily that maybe should belong in the Constitution. We also see that that's a two-way street as well. Um, but are there some opportunities for a constitutional cleanup in Article 6, where the process should be amended?
Right. This is where you get into, for instance, selection of justices and selection of judges. Right now,
Right.
we elect the judges at the local level. District judges are um, the probate and circuit courts, and then appeals. And we're not unusual in doing that among the states, but um, but it's not a common practice, and a lot of other states will have a process to identify best candidates, and then there's some appointment process from there, or the gubernatorial appointment. Um, so that's a sort of cleanup thing, I think, to look at how are we doing it. That's not to change the structure of the court, but who ultimately makes its way to the courts. Um, Separate from all this, we've been thinking about the way that we choose our Attorney General and Secretary of
Right.
State, and how we choose um, our boards of the Michigan State, and Wayne State. Here's another topic that falls into that same category, that the justices, Supreme Court justices, are nominated by party committees, party caucuses,
Well,
and then they
exactly.
run on a nonpartisan ballot, which doesn't make sense.
It's hypocritical on its face.
It is on its face, and everybody sees right through it that those are candidates supported by one party or the other, and the idea that they're nonpartisan at the time of election. I don't want to take anything away from justices that make it there and do their best to be
Right.
nonpartisan and everything, but at the time of election, that party nomination carries a lot of sway in how people are voting.
There's also this looming question about who is really in charge. Section 14 designates the county clerk as clerk of the courts, but is the clerk of the courts really in charge of the courts if the state is ultimately in charge?
Yeah, that's a, so the clerks, whether the county clerks or municipal clerks, in the case of our city district courts, um, they have sort of two masters that they work for the city and maintaining all of the running elections and doing all the fun stuff that goes with that. But they're also the administrative arm of the courts, circuit courts, probate courts, district courts. And that has a lot of responsibility. Ultimately, it's the judges setting the dockets and everything, but um, to have that shared responsibility, we could make the case that perhaps the courts should have the authority, the funding to hire their own administrative staff, um, the stenographers, everything that happens behind the wall that we don't see when we're sitting in a courtroom. Um, and that would free up the clerks, the municipal clerks and county clerks, to focus on local government issues, not the judicial side of the triangle.
So, all items that we could be talking about in a constitutional convention. As we look at Article 6, one of the things that can get a little thorny and a little awkward, and we have seen this with the politicization of so many things, and that is when it comes to a judicial appointment by the governor. We have seen, not unlike the Supreme Court of the United States, where if there's going to be a changeover in party, there's kind of this push to maybe force out an older justice that is getting close to retirement so that the governor can fill that vacancy and create an incumbency opportunity for somebody. Is that something that it's just one of those niggling things that is kind of frustrating with the process? Is it ripe for a constitutional fix?
Yeah, I think that gets back to the whole way that we select justices. I think always there will be an opportunity for governors to fill vacancies, and the saying that politicians will politic will certainly play into that. But is there a way to safeguard the process in some way? As I said, some states will have a judicial selection committee that goes through and vets
Right.
and say, here's three very capable candidates. They've all passed musters, and there's some bipartisanship to that or nonpartisanship to that. And then it's about the um, the qualifications of the candidates and maybe who fits within the political purview of the governor, um, but maybe take away some of the game playing with all of that, and it becomes less of a process to handpick that person coming in. It slows the process down for sure, so that things cannot happen within the 11th hour of the term as we approach an election.
Yeah.
So there's a lot of room for improvement on that, and we're never going to take the politics out of politicians, but how do we safeguard it for the people a little bit more?
Are age limits something that may be a focus of debate?
For sure.
Right now it's age 70, right? For
Age 70, right. And, you know, we think a little bit about the pay of the justices, and that gets caught up with the Legislative Compensation Commission that we talked about in the earlier podcast. So, um, what we see in the legislature because of the pay issue is that we get young people and older people. And I think for justices and judges at the same time, having the pay being an issue, that maybe they can make more in the private sector, but in their final hours, or I don't want to age discrimination, things like that. But as I get on in life, maybe they're less interested in doing the hard work of lawyering and can sit and benefit from their years of being a lawyer to adjudicate provide justices. So having 70 years as an upper limit might work against us in some ways. At the same time, we know age comes with some downside and cognizance and things like that. So it's something we should look at. People are living a little bit longer now than they were in the 60s, and 70 isn't such a barrier. I
Yeah.
say as I quickly approach that threshold.
Yeah. As you and I keep reminding ourselves that age is just a number.
It's just a number.
That our perspective on this changes.
Remind
Um,
myself every day when I wake up.
yeah, who is that guy in the mirror? Um, as we look at, well, you brought up the State Officers Compensation Commission. That could be something that could get a lot of attention because, I mean, we are seeing in some counties, we've got Supreme Court justices in this state that are earning less than what some circuit judges are making.
Yeah, that gets to a couple of different issues. The big one, which is not related to the judicial branch, but the judicial branch is affected by it, is how that State Officer Compensation Commission works and who's affected by it.
Mm-hmm.
As we discussed in the earlier podcast, there's been a lot of game playing with that and sort of how politicians want to be on the line for giving themselves pay raises, or are they should they be okaying it or rejecting it, that type of stuff. And I think the judges, because they're tied into that, have been collateral damage on that. They acted to affect the pay of judges in some ways, but it hasn't helped in the big picture. But to your question, part of the problem is we have a system where the state provides some funding and the local governments provide the balance of the funding. And so, as we know, there's wealthy parts of the state and less wealthy parts of the state.
Right.
And
And
so
that compensation should also be determined by what the relative cost of living is in the area in which the judge is practicing, right? You can make
uh,
that argument. And then
you,
the other
you
side is, shouldn't you have something that's equitable throughout the state so that you have a floor?
equitable, and you don't want to penalize a judge that may have a heavier docket because of the place that they live, but there's not the wherewithal to pay them on a scale needed um, to come on par with their peers in other counties or other communities. So how we're paying the judges is going to be an issue, but it needs to be, I would hope for those delegates, like laying out the framework and not being heavy in details. This is balance of how much is constitutional issue and how much should be left to the legislature to implement.
All right. So taking that the next step, how we pay judges, there's also, and you point out in your paper, which for our listeners and viewers, you can check that out at crcmich.org. And that is the whole idea about how we fund the courts. Again, there is the one state court, but there is language here over trial court funding that could be perhaps the most contentious part of the debate should Article 6 be open for discussion.
Right. Again, if we think back to before the 63 Constitution, and we have municipal courts and county courts, and there wasn't really that hierarchy that existed before, and so each one was responsible for the court funding. As we created the one court of justice, the state stepped in some way to provide funding for the courts, to provide some share of the funding of the judges, but it has never, even though it is stated on multiple occasions, the state has stated, a bit of redundancy there, the intention for the state to be the source of funding, that the cost of that burden has always been too high, and the state has never lived up to that.
Right. It's 3 or 4% now of total court funding comes from the state.
A relatively small share, for
Yeah.
sure. And so as we think about, how much of how well this Article 6 has worked, you would give it good grades, but if you looked at court cases that have been related to Article 6, you would think there was real issues, and most of it is tied to this question of court funding. For when a district court or a circuit court, probate court judge says we need to update the courthouse, we need to fix up the chambers, we need to fix things, and we need more staff to do this and that, that butts up against the cost of running a county or a city who are under their own restraints and their ability to push back to say, this is the budget we have to live in. So how we're funding the courts, how we're funding the judges needs to get fixed. It could be done legislatively if the state were to step up and take more of that responsibility that it has stated many times is its intention. Perhaps a provision in the Constitution saying it is the state's responsibility to fund one court of justice would be the kick in the pants needed to get it done.
Yeah.
I don't know that it's going to happen until then.
Because as you point out in your paper, and I thought this was interesting, you've got the situation then where there's a lot of pressure on either clerks or judges that are operating the local systems to institute fees or assessments to come up with some kind of revenue generating vehicle to make up for those shortfalls, which may not be in the best interests of justice and could actually provide a financial barrier for some.
Yeah, we see, as you say, the fee structure, and the courts have said that that's unconstitutional, and they've charged the court funding, trial court funding commission to come up with a better structure, and has offered ideas. We also see communities where you post the sheriff or the local police out on the road to, according to Barty Fife, hiding behind the billboard waiting for speeders, and this is a way of bringing in the revenues for the court to pay for itself.
I thought I was funding the library, Eric.
Well, you would think so, but if you cop to the charge, it doesn't all flow to the library. That's an conversation for a different article of the Constitution. So, the effect that we've left this to the local governments, and not all local governments are equally endowed with the ability to pay for the courts, and they all have budgetary processes they have to go through, balancing the needs of the courts against the police and public works and every other service that they provide, has created a lot of friction, and clearly something that will need to be addressed if there is a constitutional convention.
And again, as we've said, that question will be determined come this November. That's 6 in the books, Eric. We'll tackle a couple more before we're done here, but I know it's been getting a lot of attention online and also on Spotify and YouTube, where you can find these podcasts from people that are interested in just kind of understanding what a constitutional convention would look like. Anything else before we put a bow on Article 6?
No, we're just happy to have people listening to this and remind them that we can do this only with their support. So the ability to come to our website and look at what we're providing, the information, so people understand what their governments are doing and the government understands the issues before them. We're a 501c3 not-for-profit organization, so your corporate and individual support is very important to keeping this going.
Or whoever came up with the phrase, a fact tank can't run on fumes, my hat off to them. And that's a good message to send. Until next time, Eric, thanks very much.
Thank you.
And remind your friends, you can find the hashtag Facts Matter podcast, Spotify, YouTube, anywhere where you might find your favorite podcast. Recommended if they, like so many people, are looking for nonpartisan analysis of the policies that affect them today. Until next time, I'm Guy Gordon. Take care.
The Citizens Research Council of Michigan has been providing lawmakers, academics, the media, philanthropists, business leaders, voters, and all Michiganders with factual, unbiased, independent information on significant issues concerning state and local government organization and finance For over a century, our research is available to you. Go online at crcmich.org and on all the social media platforms, Twitter, Blue Sky, Facebook, Instagram, LinkedIn, and download our research. Check out our numerous papers and blogs, and listen to our podcasts. And while you're there, please consider supporting our research with a donation. This has been a Facts Matter podcast, a presentation of the Citizens Research Council of Michigan.